Hello, check. Hello, check. Hello, check. Check.
मला पण लागा माहित आहे.
Hello, check.
म्हणजे लिंक लिंक
Hello, check. Hello, check. Hello, check. Hello, 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 check. Hello, check. Check. Hello, check. 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 Check.
Start live.
Hello, hello, check. Hello, check.
Hold on.
Check. Hello, check. Check. Hello, check. Hello, check.
पूरा विजन में आएगा तो बोल देगा कोई दिक्कत नहीं एटलीस्ट ये तो बोला मैं एक काम करता हूँ कि बिना किसी बच्चे से लाइव कर सकता हूँ इसलिए मोबाइल के थ्रू भी वो लाइव हाँ मोबाइल से मोबाइल बोल रहा होगा बट उसमें दिक्कत क्या होगी उसका पता यहाँ उसको स्कैन लेके देखा हेलो आगे भी हेलो हेलो क्लियर आप किसे हो गए जसं आपल्या
Hello, guys, please keep your phone on silent. हेलो 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 हेलो
इसको पकड़ो, इसको यहाँ पे पकड़ो, एक जने को और बोलो, एक जने को और बोलो।
हाँ ये कोई मफल है बट ठीक है आई एम इट्स ऑडिबल
एक मिनट रुको, एक मिनट टेबल मंगाता है पहले, टेबल 1 मिनट रुको, 10 मिनट लगेंगे।
ये बस सर है कैमरा वही लगा देता है वो लाइव स्ट्रीम पे मैं आ रहा हूँ से हाय गणेश वो टीवी है सर चार्जिंग पॉइंट वहाँ पे है ना सर उस स्टेट लग जाएगा ना तो चैनल आ जाएगा सब आ जाएगा एक बार कंप्यूटर की 1 मिनट आप बताओ आप ये कैमरा वाली चीज़ ये कैमरा वाला उठा वो तो सामने कुछ लगी
आते रहता है।
सर यहाँ लग
कोई शक्ल भी नहीं दिखेगी।
इंस्टाग्राम लाइव कर देंगे जस्ट फॉर दिखाने के लिए भी जा रही है उनकी टेबल जैसे टेबल की कितना आ गई
चलिए बने और कोई और डिजाइन बैठ सकते हैं। फैन है क्या किसी पर? अरे चाबी ले ले।
इसके ऊपर फोन लगाना है।
आगे ठीक है डन ये लो क्या ऊपर वीडियो पूरा
नहीं ठीक है।
बिल्कुल ठीक है ठीक है बिल आ लेना
सही पहुंच।
सुनो लॉजिक है पोडियम मान जो बोले लगे अच्छा पोडियम भी आ रहा है ना छोड़ो
हाँ वो पूरे मार
आ रहा है
हाँ पूरे
बीच
खड़ो तो पूरे मार खड़ो खड़ो यार हमारी
ऐसा स्टैंड
शायद किसी को आगे वो तो
जैसे ये है ना
ये वाला इसमें बीच में खोल दो।
नहीं मैं बता रहा हूँ ऐसा स्टैंड है ना वहाँ जाके लेते हैं कॉन्फ्रेंस वाला है ना कॉन्फ्रेंस हॉल पे एक ऐसा स्टैंड पड़ा है वो लेके आ जाओ यहाँ पे तो बिल्कुल ऐसे चल जाएगा वो नीचे ना वॉचमैन जो भी उसको बोलना वो वेट बोल देगा माइक जो लगाओ माइक को वहाँ पे है ना ड्रॉर में रख के आना ठीक है ना तो स्टैंड ले बाय बाय
Readings to the honourable bench. It may please the bench, may the bench be collectively referred to as my lords. My lords, this is counsel appearing on behalf of the petitioners in the matter of Antonius Pius versus Union of Marwa. The counsel shall be dealing with issues number 1 and 4, while my co-counsel shall be dealing with issue number 2 and 3. I shall be taking 15 minutes of the court's precious time, while my co-counsel shall be taking 30 minutes. If my lords of government may proceed with the argument. My lords, the first issue beforehand is whether there are well-established mechanisms under the existing regulatory regime dealing with the grievances sought to be raised. My lords, the stance of the petitioners is answered in negative. That is, the petition ought to be maintainable before this honourable court of law. My lords, the petitioner's arguments the structure of the arguments is such that firstly both Akshaya Private Limited as well as Mandor Telecom Nigam Limited fall within the purview of state for purposes of Article 12 of the Constitution of Marwar. In such capacity, my lords, they have been causing a grave violation of the fundamental rights of the petitioners. And further, my lords, they have been causing the abuse of the monopolistic position which they occupy in the market of social media. Now, my lords, where there exists such a violation of fundamental rights and a monopolistic abuse of powers, there is this honourable court to exercise its jurisdiction. If my lords may permit, may I proceed with the main one. My lords, the first limb of argumentation is that Akshaya Private Limited falls within the purview of state for purposes of Article 12 of the Constitution of Marwar. My lords, for this reference, the public function test is to be looked into. My lords, may refer to page 115 of the compendium, para 30 of the judgment, delivered in Dr. Janet Jaipal versus SRM University. Well, in the case, SRM University, a private deemed university, was accorded the status of state. The reason being that it performed an important public function, that being of providing higher education. Now, Lord, let us consider what Akshaya Private Limited does in the instant case. Lord, it is a body which controls such social media platforms, and it is a body which is regulating fundamental rights of the citizens, like the right to freedom of speech and expression, the right to form unions online, the right to carry on trade and occupation, and the like. And further, my lords, in the landmark case of Packingham versus North Carolina, as has been relied upon by this honorable court several times, internet has been described as a modern public square in today's sense. Thus, my lords, it ought to be noted that when such a public space is left unregulated today, the same poses a grave threat to the fundamental rights of the people, like the petitioner. If my lords, the permit may proceed with the second limb of argumentation. My lords, even if I consider for instance that the body does not fall within the purview of state, in the judgment delivered in Kaushal Kishore versus State of Uttar Pradesh, my lord, it was held that where there exists a violation of fundamental rights under Article 21, even private entities can be moved against. Further, my lords, in the judgment delivered in BCCI versus Cricket Association of Bihar, that is page 21 of the compendium, my lords, it was held that when body exercises such a monopoly in the field which is not diluted by the state, it should be amenable to the writ jurisdiction, because in the other case it would be redundant to the fundamental rights of the people. So, my lords, moving on to the next limb of argumentation, it ought to be noted that there has been a violation of the fundamental rights of the petitioners under Article 19 and 21 of the Constitution of Marwar. My lords, Article 19(1)(a) envisages the right to freedom of speech and expression. So, my lords, in the instant case, in the instant case, what has happened is that merely as a result of an independent piece of publication, merely on a suspicion that such publication could pose a grave threat, although the publication in actuality, as I shall be reading later as well, was acquitted by the Honorable Court of Law as not being defamatory. My lords, on this basis, a chilling effect on freedom of speech and expression occurred, and his rights to these social media platforms was restricted. Further, my lords, as held in the case of K.S. Puttaswamy versus Union of India, the right to privacy is a fundamental right under Article 21 of the Constitution of Marwar. In the instant case, my lords, there have been two basic violations to this aspect. Firstly, my lords, the Akshaya Private Limited requires an Aadhaar-based authentication in order to access the platforms in the first place. Section 57 of the Aadhaar Act, my lords, was declared unconstitutional on the same basis that allowing third parties to do Aadhaar authentication would not be in consonance with the right to privacy. Further, my lords, it has, as has been specified in the Moot proposition also, that is in para 5 of the Moot proposition. And my lords, the employees of Akshaya Private Limited, as has been proved by the forensic analysis also, have caused a data breach, that they have leaked the private data of the petitioner, his search history, the purchases made by him. Further on, my lords, they have even recorded his offline conversations what justification can be given for the recording of offline conversations of a petitioner without his consent whatsoever in any manner? If my lords may permit, I would like to refer to the case of Central Public Information Officer versus Subhash Chandra Agarwal. Because in the incident case, the right to anonymity was held as a part of right to privacy. In the incident case, my lords, leave apart by leaking his search history, what he was doing on the internet, which was even though it was public at a point of time, but the same was ought to be kept anonymous upon his consent. However, my lords, the same was not kept conformed to by this platform. So, my lords, lastly, discussing the scope of the powers of this Honorable Court under Article 32. My lords, in the case of MC Mehta versus Union of India, that is page 71, para 33 of the judgment. I quote, my lords, Article 32 does not merely confer on power on this court to issue a direction, order, or writ for enforcement of fundamental rights, but it also lays down a constitutional obligation to protect the fundamental rights. And in such capacity, they hold all ancillary powers to issue bold new remedies as well as fashion new strategies. My lords, in the past, as in the case of Vishaka versus State of Rajasthan, this Honorable Court, taking cognizance of the issue beforehand, where the legislative gap existed, this Honorable Court issued necessary directions till the time the legislature stepped in and took some action. The same is what we seek, my lords, that even if it's a blockage of restriction of access to such platforms is required, there ought to be an independent third body nominated, which first oversees whether such restriction is reasonable or not. Also, my lords, the terms of usage of such platforms, as my co-counsel shall also be explaining, are of an arbitrary nature. There is no kind of any bargaining power. Either you accept the terms and conditions or you give up on your fundamental rights. My lords, this cannot be accepted in a constitutional setup like that of Marwar. So, my lords, I would also, in this reference, I would like to point out who is the powers of this Honorable Court, Article 142. That is to do complete justice to the parties. The court is empowered to issue any such necessary directions and orders. So, my lords, in the instant case where there exists such a grave violation of fundamental rights, this Honorable Court ought to take cognizance, and this petition is thus maintainable for this Honorable Court of Law.
You said that the offline content which was available with them they have to be utilized. Have you heard of the right to forget,
Certainly, my lords.
and where how does it stand in furtherance of Kutuswami?
It stands in furtherance of Kuttaswamy, my lords, that Kuttaswamy says that you have a right to privacy. That is what you are doing in your personal space is not to be made public. So, my lords, even if certain activities, which even if he is doing in his personal capacity, but they are public at a point of time because he is using the public
So has
platform.
right to forget been adjudicated by the court?
Uh, Mullah, I'm not aware of the name of the case. However, this court, honorable court, has recognized in the context of privacy breaches that the right to be forgotten has to be held to be an implicit part of right to privacy. Because the right to be forgotten, the essence of right to be forgotten is that even if some personal information was public at a point of time, if the user does not consent to it being to be made available in the public domain, the same cannot be done.
But once you have given in writing to abide by the conditions, then how can you turn back and challenge this thing?
Certainly, my lords, it must be noted that even if I have given my acceptance to terms and conditions, in the case of Bashishta Nath versus CIT, my lords, it was held that one cannot waiver of his fundamental rights. My lords, how can I consent to the fact that if I do something, my fundamental rights will be
You
taken?
agreed to do so. You have given knowing fully well that you have this fundamental right, still you sign the paper by
Uh,
giving an agreement, by signing an agreement.
Mullah, the same is a part of the second issue which the co-counsel should be dealing with. However, to satisfy the bench at this juncture, I would like to point out was the fact that the such terms and conditions form the essence of browser-up agreements. And Mullah's browser-up agreements per se in contractual jurisprudence have held to be as a general clause they are not binding. The reason being that there is no actual knowledge on part of the user. Plus, if I am giving my consent to the usage of these platforms, it does not mean that I am consenting to the violation of my fundamental rights. Plus, even if they consider that my content was objectionable,
So
they could have.
and you challenge the very inception of this because that violates the fundamental rights.
Certainly, my lord.
The moment you sign the paper, before signing the paper, you can come out with the case that look here, you are getting an agreement executed with me, which is in violation of the fundamental rights. Therefore, the terms and conditions of that agreement should be modified.
Certainly, my lord. However,
Because you are signing it, fundamental rights are in existence prior to the signing of the agreement also. But
certainly,
with wide open eyes, you are signing that agreement, knowing fully well that abide by.
My lords, what is ought to be noted at the such agreements are in the nature of unilateral agreements. The petitioner does not have a bargaining power to even question whether such terms and conditions are reasonable or in consonance with the fundamental rights. It is only when a breach of it is only when a question arises as to whether such terms and conditions are enforceable that this contention is being made by the petitioner. If my lords, the forward may I proceed with the next issue. Well, the next issue up for consideration is that whether an absence of any statutory provision enshrining presumption of innocence can the petitioner claim any appropriate relief, and the well-established principles with respect to honourable or technical acquittal be disturbed at this juncture. Well, it ought to be noted that presumption of innocence entails natural justice, and which is this part of the basic structure of the Constitution of Marwar. Because natural justice in turn forms the basis for rule of law, and rule of law has been recognized in Keshananda Bharti versus State of Kerala as a part of basic structure of the Constitution of Marwar. So, my lords, in this statement, I would like to make a twofold argument. Firstly, my lords, it ought to be noted that the suspension order itself has been framed upon grounds which are very vaguely defined. The my lords, it must be noted that the charges leveled against the employees are that of misconduct and insubordination. Now, Mills, in the case of Tata Oil Mills versus Union of India, it was held that misconduct involves such activities as done in the course of employment or have some connection with the employment. So, Mills, let us consider the instant case. Mr. Antonius Pius is employed as an engineer at Mandor Telecom Nigam Limited. What he's posting Malod firstly is in his capacity of being a journalist that is outside the course of employment, and further Malod the same has no connection whatsoever with the employment. The offence of misconduct here does not fall. And Malod, when the charge sheet was issued against the petitioner, the reasons, the basis on which the charges were framed was not even given. And Malod, when further the second charge, that is of insubordination. In the case of Anand Patrika versus Union of India, Manoj, it was held that insubordination involves such violation of the orders of the superior or a violation of the superior's authority. Thus, it must be considered that firstly, how can a management be expected to regulate the conduct of an employee outside the course of employment and outside the premises? Furthermore, even if I consider so that there exists a provision, then the company may provide the same the specific rules and regulations as established in the certified standing orders, which they have failed to do so. Further, my lords, it must be noted that what they are claiming is to be detrimental to the interests of them. My lords, mere impediment in a case before a court of law does not constitute any detriment to the interests of the business, because even subsequently they got acquitted because there was no merit in the case itself. If my lords be satisfied, may proceed to the next limb of
In
argumentation.
conduct rules, your writer says that you are governed by the conduct rules. The conduct rules has a provision wherein the conduct of a person outside the employment is also taken note of if it damages the prestige of the institution. Then the overall conduct of a person is required to be taken into consideration while dealing the while he is serving in a particular organization.
So
If this conduct has led to this channel some defamatory or some bad name, then the proceedings are required to be undertaken, not merely because something has not been done between 10 to 5 in your working hours. But if you are a government servant, regulated by service regulations of whatever the compilation says of these regulations, then you are supposed to behave in a gentleman manner after the working hours also.
Must acknowledging Malord's wisdom at this point. However, Malord's what the connection we're trying to draw. That Malord's we agree that the employee is expected to act reasonably even outside the course of employment. However, Malord's when we have to consider the charges which are being leveled against him. Lords, even if they consider that there is misconduct on our part, it is objectionable on our part, Malords, they may have provided us the basis for the same. That on what basis you have they formed such opinion? Merely framing the charges of misconduct and insubordination and passing a suspension order. Malords, the suspension order has been pending for the last 6 years. And Malords, it must be noted, as I shall be dealing further also, Malords, they paused the disciplinary proceedings during the pendency of the trial. And when the trial decision comes, my lord, that we are acquitted, Now they say, my lord, that your technical the acquittal is technical. We are not bound to accept it. Thus your distribution cannot be dropped. So, my lord, when no consideration in the light of justice, my lord, will grant extension. My lord, it must be noted that
The employer has the right the employer has the right to evaluate and examine the suitability of the employee and also see whether the credentials and his antecedents are proper or not. If the
certainly.
employer finds that he is not suitable for continuing in his services, he has the right to discharge from or dismiss him from service.
Certainly, your leadership. However, what is important to note at this point is that if they say that you were expected, you were that we they paused the district proceedings for the trial to commence, and when the trial court gives the decision, they said that we are not bound to accept it. So, my lord, what the point being made is that for 6 to 7 years you keep me on suspension. Well, on one hand, I am being debarred by Akshar Private Limited to carry on journalism. On the other hand, even you debar me from working. I am not claiming bounty amount. I am claiming the amount which I am entitled to, my
Fine,
lord.
but the acquittal in the criminal case will not discharge you from the disciplinary proceedings undertaken by the department.
Certainly, my lord.
Both the set of proceedings stand on different footing.
Certainly, my lords, both the set of proceedings stand on different footing. However, this categorization itself was brought into the Consular Service Law, where it was recognized that where the same set of activities form the charges, then the acquittal in the criminal case, why is it to be considered? If it is an honorable acquittal, why is it considered as well?
No, the Supreme Court says otherwise because acquittal in the criminal case will not automatically discharge you from the disciplinary proceedings because the set of evidence in criminal proceedings has to be proved beyond doubt.
Certainly.
Where that fundamental rule is not applicable in the disciplinary proceedings.
Certainly, my lords, in district proceedings, the standard of proof is that of a preponderance of
Right?
probability.
Therefore,
We must acknowledge that.
therefore, it will not automatically discharge you from the disciplinary proceedings.
Certainly, my lord. However, what we are claiming is not an automatic reinstatement. What we are saying is what is the reason for the undue delay in the suspension order, the prolonged nature of the suspension order. Further, my lord, even the Central Civil Services rules as well as the Industrial Employment Standing Order Rule 1946 suggests that even if you want to suspend me for an indefinite basis, my lord, I am entitled to my subsistence allowance. No answer has been given by the management as to why I have been deprived of my subsistence allowance. Subsistence allowance is I am entitled to 50% subsistence allowance up to 90 days, 75% above that. And after 180 days, I am entitled to a subsistence allowance of up to 90%. Well, leave apart 70, 55%, 50%. I have been paid no amount. Am I claiming a bounty amount, my lords? What I am claiming is what I am entitled to. I am still in the employment roles of the company. They are not. I cannot work elsewhere as well. So, my lords, I am being deprived of my rights from all the contexts. How I supposed to exercise my rights? Is what I am trying to contain.
Were you moonlighting?
Uh, what more?
Were you moonlighting?
Certainly not, my lord.
When you are practicing two professions, you are in a service and you are also trying to do a journalism.
My lords, in any contract of employment, when a bar is placed upon his working elsewhere, the bar is to play work in a competitive business or business engages in similar activities. Plus, what I am doing is I am doing journalism in a personal capacity. I am not doing it in any manner which can affect the business interests of my employer.
You gain protection for your journalistic activities on the professional side.
My lords, sorry.
Are you claiming some kind of protection that a journalist has
Certainly not.
while you are, indulging in journalist activity, so called?
So, my lords, I'm relying on a basic sense that the journalist is entitled to freedom of speech and expression. No, my lords,
So you are seeking protection as a citizen or as a journalist,
my lords, what I am
or
seeking,
both?
my lords, I am seeking protection as both. Because the fundamental rights are that of a citizen, and even a journalist is a citizen at last. This constitutional scheme has been framed in such a manner that you are a journalist, you are an engineer. At the end, you are a citizen, and the fundamental rights are that of a citizen and not that of an engineer or that of a journalist. Um, if my lords have found, I conclude with the issue. No, my lords, lastly, what I would like to bring to the attention Lastly, what I would like to bring to the attention of this honorable court is that in the case of state of Madhya Pradesh versus Ramashankar Raghuvanshi, that is page 122 of the compendium, a similar situation arose where the employee was dismissed. My lords, and what happened was that the charges were framed because he made some comments on the basis of his political affiliation. My lords, in the instant case, leave apart any political affiliation. What I am stating are merely two facts. And my lords, even leave apart the acquittal in a criminal case. My lords, the basic requirement for defense against defamation is truth. My lords, what I was stating was fact, and the fact is a fact. It is not false. And my lords, on the basis of what I am saying, you say that you are causing misconduct. You do not provide me any justification for the same. And then you expect me not to come before this honorable court of law and wait for the proceedings to go on till for more 10 years. It was an honor pleading before you.
Leading to the honorable bench, your Lordship, this is counsel appearing on behalf of the petitioners in the case of Antonius Fires Limited. In the case of Antonius Fires versus Nluj-Nhrc, the counsel shall be dealing with the issue second and third respectively. Your Lordship, the second issue that pertains to whether denial of access to the named internet platforms can held to be a violation of any human rights. Conversely, have been accepted to the terms of use of service of these platforms in question is the petitioner bound by this. Your Lordship, in this instant case, due to the restriction of these internet-based platforms, Akshay Limited, under the garb of their monopoly status, have committed a grave violation of fundamental rights. By restricting the petitioner's access to free speech, his freedom to practice his profession, even limited his right to form association. And moreover, Your Lordship, these rights have not only been recognized by our constitution but also been recognized in various international conventions as human rights. Secondly, Your Lordship, even if the consent was taken, however, Your Lordship, in first place, these browser agreements are not to be considered binding, and more importantly, Your Lordship, one cannot give up upon their fundamental rights itself. Your Lordship, the council shall be proving the same in a three way manner. Firstly, the council will try and establish that access to internet-based platform is an enabler of various fundamental rights. Secondly, denial of access to these platforms are a violation of human rights. And lastly, one cannot give up upon their fundamental rights even after accepting the terms and conditions. Your Lordship, in the landmark judgment of Anuradha Bhasin versus Union of India, this honorable court has held that right to internet is also protected under Article 19(1)(a) and 19(1)(b) of the Indian Constitution. The restriction upon such fundamental rights should be in consonance with the mandate under Article 19 subclause 2 and 6 of the Constitution. That should be inclusive of the test of proportionality. Moreover, Your Lordship, an indefinite ban on internet is a violation of human rights. Your Lordship, it ought to be noted that in this instant case, the petitioner was an investigative journalist. In a short span of time, he had a huge amount of following on his YouTube channel, thereby indicating his quality of work. Your Lordship, by restricting access to such platforms, not only the petitioner's right to free speech was violated, but also his right to practice his trade and profession. Moreover, Your Lordship, it also ought to be noted that these platforms, as mentioned on page 3, para 8 of the Moot proposition, comprise of 95 to 98% monopoly in this market. Furthermore, Your Lordship has also held in the landmark case of Packingham versus North Carolina, the US Supreme Court held that social media perhaps provides the most powerful mechanisms available to a private citizen to make his or her voice heard. Furthermore, Your Lordship, even in the landmark judgment of Anuradha Bhasin, it was held that non-recognition of technology within the sphere of law is only a disservice to the inevitable. Your Lordship, it ought to be noted by a bare reading of Article 19 subclause 2 that provides for reasonable restrictions that could be imposed. That states that nothing in clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as much the law imposes reasonable restrictions. Your Lordship, herein we should consider the term reasonable as defined by the Black Laws Dictionary. That means fair, proper, or moderate under the circumstances. Your Lordship, it ought to be noted that in this instant case, the act done by Akshay Limited of restricting access to all social media platforms was not moderate or fair under any circumstances. Less intrusive measures could be taken at that time. The Akshay Limited could have given a notice to the petitioner, could have taken down that video, or could have restricted the access to that particular platform YouTube. But however, restricting access to all of these platforms was not reasonable at that point of time. Moreover, However, in this instant case, that access could have been revoked on that particular platform. We do acknowledge that there could have been measures taken, and your logic it also ought to be noted that at present time, when this access was restricted was the year 2011. Then there were no guidelines in place that allowed Aksha Limited to commit to restrict the access at that time. Furthermore, Your Lordship, also in the landmark judgment of Muhammad Zubair versus State of NCP of Delhi, this Honorable Court has granted relief in the past to a petitioner who used Twitter as a medium of communication to dispel fake news and held that passing an order restricting him from allowing his access on social
Assume that the news which has been the article or the material which has been raised by Anthony was correct. It was only because his investigative material which has been placed on record. Whether it was right or wrong,
Your Lordship,
he
it is
certified it that it was the channel was doing something wrong.
Your Lordship, the Moot proposition is very clear about the fact that Antonio Pius Limited merely illustrated two facts. It was the other journalist who had made this connection and the rumors had been violated. Your Lordship, it also has to be noted that Antonio Pius had only stated two facts, his access was revoked to all the platforms. What about the other people who had committed, who started these rumors, who started this rumor mill? Furthermore, Your Lordship, it also be noted that in the landmark decision of Muhammad Zubair versus State of NCT of Delhi, this honorable court held that if we restrict the access of a journalist who use Twitter as a medium of communication to dispel fake news would amount to unjustified violation to freedom of speech and expression. Furthermore, Your Lordship, secondly, that denial of access to these platforms are also a violation of various human rights. Your Lordship, Article 19 of the UDHR states that everyone has a right to freedom of opinion and expression, and this right includes freedom to hold opinions without interference and to seek, receive, and impart information through any media, regardless of any frontiers. Furthermore, Your Lordship, even Article 19 subclause 2 of the ICCPR also held that protects the right to freedom of speech and expression through any other media of his or her choice. Your Lordship, it also be noted that the Human Rights Committee of the UN also has acknowledged the danger to freedom of expression from media monopolies and the relation of Article 19 to this. Your Lordship, if you may please refer to para 13 8th line of the Moot proposition, wherein Your Lordship Akshay Limited has committed an abuse against the petitioner by restricting his access to LinkedIn, then showing up his profile as a suspended employee, in leaking his private data on the internet. Moreover, even recording the petitioner's offline conversation without his consent. Your Lordship, it ought to be noted that in the land that firstly, even if the petitioner did accept to the terms of use of these platforms, however, the first point ought to be noted that in any of these platforms, the terms and uses does not state that we will be recording your offline conversation. That is not a term written in anywhere in any of the platform that are controlled by Aksha Limited. Moreover, Your Lordship, in the landmark judgment of Kolkata Tennis versus Bombay, wherein the Apex Court held that no individual can barter away the freedom conferred by the Constitution and the concession made by him in proceedings, whether under a mistake of law or otherwise, that he does not possess these fundamental rights, and will not create an estoppel against him. Moreover, Your Lordship, the Council would also like to reiterate the views given by Justice Bhagwati in the landmark judgment of Bhasheshwar Nath versus CIT, wherein he held that Constitution adopted by our founding fathers is sacrosanct, and it is not permissible to tinker with the fundamental rights vested in it. And if such a concession is imposed, it would defeat the entire purpose of our Constitution. If Your Lordships have no further questions, the Council seeks permission to the third issue. Much obliged, Your Lordship. Your Lordship, the third issue that deals with whether categorization of an acquittal as honorable or otherwise is illegal and in violation of fundamental and human rights guaranteed under the Constitution and applicable international conventions. Herein, Your Lordship, due to the categorization Herein, Your Lordship, due to categorization of the petitioner's acquittal based on a trial court judgment by disciplinary authority is clearly in violation of Article 21 of the Marwari Constitution. That states that the same principle has also been recognized in various international treaties and conventions. Furthermore, Your Lordship, there also existed a legitimate expectation on part of the petitioner for fair and unbiased treatment arising towards him out of his conviction of the trial court judgment. Your Lordship, Article 21 of the Marwari Constitution states that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Also protects the right, and this also protects the right to live with dignity as recognized in the landmark judgment of Menka Gandhi versus Union of India. Herein, Your Lordship, keeping in mind the term procedure established by law, the Council would like to point out that no grounds of categorization of an acquittal has been nowhere laid down or incorporated in any statute of our country. Furthermore, Your Lordship, elaborating the same view, the court in the landmark judgment of Francis Corelli versus Union Territory of Delhi held that life includes the basic right to live with human dignity and all that goes along with it. However, your lordship, due to this categorization of an acquittal, even after getting acquitted, the petitioner is being treated as guilty by the disciplinary authorities by way of reason that acquittal was on technical basis and not honorable. Your lordship, the council would also like to bring to note that for the time being, the disciplinary proceedings commenced for as long as 9 years, and in the landmark judgment of Premnath Padi versus Registrar of High Court of Delhi, the Honorable Supreme Court held that that the departmental proceeding at maximum should conclude within 6 months and at the last should conclude within 1 year. However, in this instant case, your lordship, the departmental proceeding proceeded till 9 years, and your lordship, the petitioner could not be employed elsewhere also because he was on suspension, and to be employed elsewhere, he needed an NOC from his present employer. His access to journalism was revoked by the Akshay Limited in this instant case. He was not able to practice his trade there also, and by the Mangalore Telecom Nigam Limited also. Lastly, your lordship, it also ought to be noted that this categorization is itself a violation of various human rights. Your lordship, a bare reading of the preamble of UDHR states that a recognition of inherent dignity of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in this world. Your lordship, the categorization is a strict violation of principle of a criminal jurisprudence on which our criminal jurisprudence was formed, innocent until proven guilty. Last year, Lordship, the Council would also like to draw the bench's attention towards Article 354, Subclause 1D of the CRPC, which deals with the language and content of judgment, which does not make any distinction by delivering a judgment. It is either an acquittal or a conviction. However, no categorization as such is permissible under the criminal jurisprudence. Therefore, your lordship, it is humbly concluded that acquittal once done should never be associated with any adjective like honorable or technical, as such post-acquittal categorization creates uncertainty and confusion and adds an additional layer of subjective evaluation that is not based on any existing legal criteria. If your lord,
People in the criminal case will not automatically entail you to get the disciplinary proceedings wrong.
indeed, your lordship, we do acknowledge that,
There will be a separate set of evidence, and in the criminal case, the evidence of preponderance and strict proof is required to be made.
however, your lordship, it also should be noted that in this instant case, the petitioner was suspended for 8 years. He had no means of earning he had no means of living a life with dignity. And the charges levied,
That is a separate matter. But you can't claim discharge of your charges from the disciplinary inquiry on the basis of acquittal in criminal case.
indeed not, your lordship. So what the council is trying to claim is that the presumption of innocence is a fact of natural justice, as also held in the case of Ashoka Smokeless Coal Limited versus Union of India, when the Honorable Court held that principles of natural justice will apply where there is a right likely to be affected by an act of administration. Similarly, in this instant case, your lordship, even if the criminal court decision was not binding upon the administration, however, they should do their disciplinary proceeding in accordance with the principles of natural justice. Your lordship,
Acquittal has no bearing.
your lordship,
Acquittal in the criminal case has no bearing.
indeed not,
You
your lordship.
can't get the discharge on the basis of acquittal.
Indeed not, your lordship. However, it ought to be noted that the acquittal in criminal case and the disciplinary proceedings had two different set of facts. And moreover, your lordship, even though that they had different set of facts, however, what these charges constituted was because of one act that the petitioner had committed of however, they were because of the one act that commissioner, the same act that had been committed by the petitioner in this instant case, and on basis of that, at both these charges were framed.
Burden of proof, as my lords are also asking you, burden of proof is to be discharged, I mean, so independently. At one place, if prosecution fails, the trial will fail. At the other place, if the person fails, it will be read against him. So it is diametrically so much opposite that you can't. And moreover, as far as the delay is concerned, there is some jurisprudence in Captain Paul's judgment and onwards that if the criminal trial is going on, the department inquiry normally is kept suspended. So maybe those long 8 years was because the criminal trial was going on. Are you aware of the jurisprudence of Captain Paul and others? That jurisprudence simply says that while the core of the evidence is the same, then the precedence has to be given to the criminal trial. So any delay which is on account of procedural part would not be, it cannot give a benefit to you.
However, Your Lordship has reiterated before that in the case of Nluj-Nhrc versus Registrar High Court of Delhi, the Honorable Court acknowledged the fact that that the criminal trial goes for a long period of time. However, the employer needs to ensure that departmental inquiry initiated against the delinquent employee is concluded within the shortest possible
That is
time.
why we have been asking you that Captain Paul says that irrespective of all procedures, stop the inquiry until the criminal trial is over if the set of evidence is same or the set of allegations is same.
However, in this instant case, Your Lordship, the allegations that were relied upon the petitioner by the disciplinary authorities and the allegation on the criminal code was very distinct. One was of defamation and another was of misconduct and insubordination. May I proceed with the prayer? Whereas in the light of issues raised, arguments advanced, and authorities cited, the counsels for the petitioners humbly respectfully pray before this honorable court may be pleased to hold the denial of access to named internet platform as a violation of fundamental and human rights, specifically the freedom of opinion and expression and the freedom of personal liberty, hold the terms of usage of service of platforms controlled by Aksha Private Limited as not binding upon the petitioner, declare the categorization of an acquittal as honorable or otherwise as illegal and in violation of fundamental rights guaranteed under the Marwari Constitution, issue appropriate guidelines in respect of violation of applicable international conventions, and set aside the suspension order passed by Mandor Telecom Representative, or pass any other such order or issue such directions that this honorable court may deem fit in the light of justice, equity, and good conscience. And for this act of kindness, the petitioner, as is duty bound, however, humbly. It was an honor to you.
Greetings to the bench. The council seeks permission to address the bench collectively as your lordship. Much obliged. May it please your lordship and the council on the behalf of respondent in present dispute. As delineated in the written submission, the council shall be dealing with first and second issue and shall be taking 13 minutes of honorable court time. The co-counsel shall be dealing with third and fourth issue and shall be speaking for 16 minutes. With the leave of this honorable court, the council humbly submits that we humbly reserve 1 minute for such rebuttal. If your lordship are well versed with facts and there are no preliminary inquiries, the council seeks permission to address the first issue. The lordship, the first issue primarily pertains to whether there are well-established mechanisms under existing regulatory regime for the grievances sought to be raised. The lordship, it is humbly submitted that there are well-established mechanisms under existing regulatory regime for grievances sought to be raised. The lordship, its point here to be noted is that the Akshay Private Limited, which control the platform like YouTube, Insta, have a digital space, and it could have a grievances in three manners, in three facets. First, it could be related to data protection or the regulation. Second, it could be related to monopoly or monopolistic market or tendencies as in the prayer of a petitioner. Lordship, third, it could be related to constitutional framework. Lordship, it is humbly submitted that regarding the first facet, there are well-established mechanisms under the Act of the Union of Marwar, which includes the Digital Personal Data Protection Act of 2023, the Information Technology Act 2000, the Intermediaries Guidelines of 2021. The Lordship, it is humbly submitted that the regarding the first act, the Digital Personal Data Protection Act of 2023, the Section 27, Clause 1, Subclause A, empowers the central government to constitute a board, and board has the exclusive jurisdiction to deal with the matter of a breach of the privacy. The Lordship, even if there is any grievances regarding the decision of a board, the provision is laid down in Section 29 of the same Act, where the appeal could be given to the appellate tribunal regarding the decision of the board. And your Lordship, the Digital Personal Data Protection Act 2023 has a well-established mechanism. Even in the Information Technology Act 2000, your Lordship, Section 79, Clause 3, Subclause B states that the intermediaries has to follow the due diligence and also exempt the intermediaries if they have performed the due diligence. Your Lordship, in the present case, the Akshar has placed a well-established mechanism, and in paragraph 5 of a fact sheet, your Lordship, the artificial intelligence has been used so that no other people could breach into the privacy or cannot log in the anybody other's account. Lordship, it is humbly submitted that the section 79, which shows the prerequisite due diligence, already lays down the mechanism. It's further submitted, Your Lordship, section 67, section 79, and section 81 constitute a holistic trinity. As Your Lordship, it was delineated in Sharad Babu Digumati versus State of NCT of Delhi that they constitute a holistic trinity. Your Lordship, it is further submitted that if they constitute a holistic trinity and they have an overriding effect until unless it is not inconsistent with other laws. Your Lordship, it is humbly submitted that that when it is asked to remove or expeditiously remove any content from the internet, the reason has to be given in writing before the Honorable High Court under Article 226, as delineated in the case of Shreya Singhal versus Union of India. And it by way of providing the regulatory mechanism, it also ensures that it should be in a equilibrium with the Article 19 or the fundamental rights of individuals. Further, Your Lordship, IT Act of 2000 also provides the provision of cyber appellate tribunal, where the grievances could also be sought to be raised. It is humbly submitted in the third regulatory mechanism under for the regulation of data. The intermediary guidelines under Rule 3A has provided the constitution of grievance appellate committee, which shall be dealing with these issues. And if there is any grievances, the appellate committee is authorized by a central government, and it is an independent body, Your Lordship. Thus, Your Lordship, in terms of data protection, the three bylaws of Union of Marwa, the Data Protection Act of 2023, the Information Technology Act of 2000, and the intermediary guidelines provide extensive framework for their regulation. Your Lordship, in the next passage,
But then the question involved in the present case is of such a vital importance, which will be affecting large number of people. So why we should be relegated to the alternative remedy available under the law? Because the question needs to be decided for once and for all. In the larger interest of the people, since it is affecting large number of people, why should we dismiss it only on the ground of alternative remedy?
Your Lordship, it is formally submitted that they had sought for that the issue was pertaining to whether there exist regulatory mechanisms or not. There exists a
Despite there being regulatory mechanism, despite there being alternative remedy available for the petitioner to go and get the redressal, this court is not, powerless to decide the issue because it is the discretionary power. And since the question involved in the present case is of vital importance to the larger public, then why not the petition itself be decided by the Supreme Court? Why it should be relegated to the bodies mentioned in the statutory laws?
Indeed, Your Lordship, the said Act, the Digital Person Data Protection Act, is a special law which governs especially the matters dealing with this, and the Honorable Supreme Court's time should not be held here. Also, in furtherance of the argument, Your Lordship, it is humbly submitted that Akshar is a private entity. Further, Your Lordship, it doesn't come under any definition of state.
Starting public function.
Your Lordship, the public function, by applying any horizontal application of fundamental rights, is only when it performs a public function. But in present case, it doesn't perform a public function. The core council shall be dealing with these issues in a detail, Your Lordship. Your Lordship, if there are no further queries, the council seeks permission to address this second subcontention. Lordship, in terms of monopolistic regulation, the Competition Commission of Laws of Marwar has exclusive jurisdiction of matters relating to it, and the consumer could have approached the Competition Commission if there is a suspicion that there is some monopoly or monopolistic practices being performed. Section 3 and Section 4 restrict the abuse of dominance. Your Lordship, it is further submitted that the consumer under Section 23, Section 24, and Section 25, the Competition Commission of India Regulation 2009 can file a complaint regarding the same. Hence, Your Lordship, there are well-established mechanisms under Competition Act as well. Your Lordship, it is further humbly submitted, Your Lordship, that the market study on telecom sector in India, as referred in page 5, para 9 of our written submission argument advanced, Your Lordship, the market study on telecom sector in India has categorically mentioned that has made an observation that extant antitrust norm framework was noted as broad enough to address the exploitative and exclusionary behavior of intermediaries. Lordship, the CCS, the Competition Commission of Marwar, has exclusive jurisdiction in these matters as well. Your Lordship, it is further submitted that there exists a regulatory mechanism in constitutional framework as well. Your Lordship, Article 194 of the Constitution of Marwar places that the committees which play the inquisitional role and the fundamental functioning of a parliament regulation. Your Lordship, under Article 194, the committee can be formed in the considering the issue of peace and order. The same was the same was done by the central government, the government of Delhi, and the case was observed as a Facebook versus Delhi Legislative Assembly in 2022. Your Lordship, if you may please refer to page 6 of our argument advance. The Delhi Legislative Assembly has made it, and in this particular case, the court has made observation that intermediaries can hardly contend that they have exceptional privilege to abstain appearing before the committee. Your Lordship, there is as well as a constitutional framework, as well while considering that there is a need for peace and order, and there is a need when the peace and order is disturbed, and we need some mechanism. The Constitution itself grants the power to central government exclusively dealing with it. Hence, Your Lordship, the first session where the breach of data is concerned, there exists a regulatory mechanism. When comes to the regulation of monopolistic market or monopolistic tendency, there exists a mechanism under Competition Act of Marwar. And when there is a need, considering the peace and order, or as central government may deem fit, considering the life or interest of a justice, in the interest of justice, may form a committee under Article 194, and where these individuals do not have exceptional privilege to abstain from the proceedings. Your Lordship, if there are no further queries, the council seeks permission to get
Mr. Counsel, see, if it was a independent social media aberration, then you could have said your response could have been right, that it could have gone to a specialized committee. Here we are dealing with the prayers which are of multi-dimensional nature, and therefore bringing them under one umbrella. You have not pointed out in your compendium as well as in your response that whether he had any remedy where all these prayers could have been dealt with cumulatively.
Your Lordship,
And if not, then it cannot go on the basis of the alternate remedy.
Your Lordship, it is humbly submitted that the first point I mentioned is that there is, if there is a breach of privacy or there is any grievances related to that, the special law is made, and the special law should give a preference over its operation. It's further humbly submitted that when there is, if Your Lordship may please reframe the question, please.
The question is that the ambit of the prayer is multidimensional. So all these prayers can be taken care of in the constitutional court, but at the same time, if you are referring to one committee or another committee or one independent specialized law, then it may not be comprehensively able to do it.
Your Lordship, the petitioner's first contention is regarding the data regulation. That is exclusively dealt by data protection, and it also holds the jurisdiction regarding the matters of breach of IPR and also the corporate trademarks. It also has the jurisdiction under Act of 2023, Digital Personal Data Protection Act. And with regards to the second and third contention, the monopolistic abuse and the constitutional framework, it is whenever it is needed, there is existence in these mechanisms, and there is not proof that there was some monopoly being practiced. Your Lordship, it is just an observation which the petitioner has thought that there is some monopoly and there is some pervasive control, and hence it is a public function, which is not in the first place. Your Lordship, there exists a mechanism and there is an efficient and ethical route provided to it. We should not accumulate or conglomerate all the issues at the hand and build a prayer in such time where the Honorable Supreme Court time should be spent here in the issues dealing with the special laws, where the central government has specifically made a law with matters pertaining to that.
Also, there is no iota of doubt that upon by way of your actions, his fundamental rights have been infringed. His right to privacy, right to livelihood. He was not extended the substance allowance by the employer. So all the more why this court should not admit his petition, and his petition should be dispensed on the ground of alternative remedy.
Your Lordship, it is indeed Your Lordship, it is humbly submitted that the council likes to refer in this point 5, and the co-counsel will be dealing with this issue in detail. That firstly, that it does Akshar is a private entity, and it doesn't come. And there was a terms of contract which was signed by the petitioner, and hence Your Lordship, the petitioner is abided by these terms of contract. Hence Your Lordship, this present it should not be maintainable, and with the terms of is there any existing regulatory mechanism? The mechanisms already exist, and the issue is just framed in an order that there is no mechanism and the petitioner can't go to any other regulatory mechanism, and hence the court should maintain this petition. There exists a mechanism, and the second issue is pertaining is not connected to this issue, the regulatory mechanism. That is connected to that whether the action at the first stage is an entity which is governed, which comes under the public duty. And in our case, the action does not
Well,
perform.
my lords have just put in the judgment which was cited by your opponent said that if any right to privacy which is constituted as a fundamental right, if it was constituted as a fundamental right, then as per that case law, any private entity would also come within the domain of the jurisdiction, Article 12.
The Lordship, it is humbly submitted that is on the premise that the horizontal application of fundamental rights, where the non-private actors are held responsible if they perform a public function. The co-counsel shall be dealing with this issue detail that they don't hold any public function. Lordship, if there are no further queries, the counsel gives permission to address the second issue. Lordship, it is humbly submitted that the second issue pertains to whether the categorization of acquittal as honorable or otherwise is violative of any international covenants of the human rights. Lordship, it is humbly submitted that the said categorization is neither violative to Article 21 of Indian Constitution that lays down the desideratum for Article 21 of the fairness. Your Lordship, it is humbly submitted that it also does not violate and India's any obligation under Article 51 Clause C, and any obligation arises out of the acceptance or ratification of international covenants. Your Lordship, it is humbly submitted that the Article 21 in the Menka Gandhi case, the new extension was provided, or I would say the extension was revived, where the reasonable aspect was recognized. Your Lordship, it is humbly submitted that administrative law and a criminal law hold a different jurisprudence. There, the administrative law bases its jurisprudence on the basis of preponderance of probabilities, where the existence of fact is more probable than its non-existence. And Your Lordship, in the present case, the accused has been charged with the cases of extortion and defamation. And extortion is incompoundable offences under Section 384 of IPC. Hence, Your Lordship, is a serious offence. It is a serious offence, and it may lead to the suspicion that the person is not competent to hold, and there is also pressure on the administration to consider that the prevention of moral turpitude should also be considered. The same was held in, if you're interested, Lordship, the same was held in Union Territory Chandigarh Administration versus Pradeep Kumar. If you may, Lordship, please refer to page 6 of our compendium, where it was held by Honorable Court that the acquittal in a criminal charge does not entitle him to a reinstatement. And even the civil services rules, the Rule 10 of civil services clearly mentions that the disciplinary proceedings can be initiated, and also, Your Lordship, the revocation of disciplinary proceedings is an exception, and it is not a rule under a civil services rule. It is an exception, and there should be some specialized reason to for the disciplinary proceedings to be revoked. And in the present case, Your Lordship, the witness has been hostile, and that witness is known for his fair judgment and unbiased judgment. Mr. Kavish Kumar in the present case, and hence, Your Lordship, it is pertinent for the department to consider his competence, Your Lordship. Hence, there is a rational nexus behind such classification, and it does not violate any international covenant, as the international covenant never mentions such categorization. It is the evolution of Indian judiciary which has evolved regarding such acquittal, and it is a reformative measure. And even if it's in a conflict with international law, Your Lordship, it is humbly submitted that national court, being the organ of a national state and not of organization of international law, must enforce national
You are emphasizing on Kavish Kumar.
Yes, Your Lordship.
If Kavish Kumar has been demolished in front of a judicial court, then what remains? He has been turned hostile, as you have just said.
Your Lordship, that
So
Kavish,
once before a competent court, it is not a question of criminal jurisprudence or civil jurisprudence, but you are depending upon one credible, strong piece of evidence or witness. And once you yourself admit that he has been demolished before the criminal court and turned hostile, then what remains is the same set of evidence, is the same fact. Then it has to go.
Your Lordship, it is humbly submitted that the turning of hostile is a technicality. And
No, it is not a technicality. The turning of hostile is a well-defined proposition which happens when the witness is no more with the prosecution. So So once he is no more with the allegation, then you say that he is credible and he is good and he is very good and will have no consequence.
Your Lordship, it is humbly submitted that trial court has given a judgment that he was acquitted in 2022. But that was on the reason that that the Kabish Kumar has become hostile, and that
Is
was
there any other evidence in the disciplinary proceedings when the main witness of the case, Kavish Kumar, has declared hostile? Can he take another step or U-turn and say something against the petitioner in the disciplinary inquiry?
Your Lordship, the civil services rules provide the mechanism where the appeal could be made for the disciplinary proceeding, and there is a fair chance given under the
So
principle of
why
natural
should
judicial.
be allowed to fetch the results of disciplinary proceedings once he has been, once the main, the architect of the case in the criminal matter has been declared hostile? What other evidence is there?
Your Lordship,
Nothing remains to be adjudicated in the disciplinary proceeding.
Your Lordship, the charges which were framed of a criminal was the extortion, and extortion is not compoundable, Your Lordship.
That's right, but what is the evidence?
Your Lordship, the charge.
Can the Kavish Kumar take a U-turn before the disciplinary inquiry and say something other than what he has said before the criminal court?
The question of compounding is not even there. As my lords are directly pointing out to you that it's not question of compounding. So don't again and again go, Mr. Consul. But you have to address the architect of your case has gone.
Your Lordship, it's submitted that the disciplinary proceeding was initiated on the count of inconduct, misconduct, and insubordination due to the video which he has uploaded.
Absolutely right. Then what is the evidence? The evidence of Kavish Kumar was the only evidence available in the disciplinary proceeding that has been demolished by the criminal court. So how the disciplinary inquiry can proceed? On what basis? What is the evidence?
Your Lordship, it is
Why should it be allowed to be continued? More particularly, if it has he has faced the rigors for 7 years, then how long the disciplinary inquiry can be allowed to go on?
Your Lordship, it is humbly submitted that again reiterating the revocation of disciplinary proceeding is an exception, not a rule. So, considering exception,
It's an exceptional circumstance because the very architect of the criminal case has been demolished.
Your Lordship, that is because the witness has been turned hostile. The case is not decided on the merits, and here the suspicion is that the upset petitioner is making a judgment or making a story back when he was a journalist, and he has a past record relating to that. And considering the services of the being a government servant, the measure has been taken by the system. If Your Lordship, there are not in the council seeks permission to rest the argument, my co-counsel shall be dealing with third and fourth issue. It was really honor to ask this for that.
Greetings to the bench. The council seeks permission to address the bench collectively as Your Lordship. Much obliged. Your Lordship, the council shall be dealing with the third and fourth issue of the written submission. Your Lordship, the third issue primarily pertains to whether denial of access to the named internet platforms in question can be held to be a violation of any human rights, and conversely, having accepted the terms of use and service of the platforms in question, is the petitioner bound by the same. Your Lordship, the Council shall first address the issue of whether denial of access to the platform is violative of any human rights. In this regard, the Council humbly submits that denial of access to any of these platforms in question is not violative of any of the rights of the petitioner in a two-pronged argument. Firstly, fundamental rights cannot be enforced against the internet platforms in question. And secondly, relationship between user and service provider arises out of a private contractual agreement. Lordship, it is humbly submitted that although the rule is that a writ cannot be issued against a private body, but the following exceptions have been made. Firstly, where the institution is governed by a statute. Secondly, where the institution is state within the meaning of Article 12. And lastly, when even though the institution is not state within the meaning of Article 12, it performs some public function. The Lordship, it is humbly submitted that it is undisputed that internet platforms in question do not fall within the ambit of any statutory authority. As far as the second exception is concerned, Your Lordship, if you may please refer to para 25 of the arguments advanced. Para 25, page 12. For an institution to fall within the ambit of other authorities as mentioned in Article 12 of the Constitution of Marwar, a test had been laid down in the case of Ajay Hasia versus Khalid Mujib. Your Lordship, the test composes of 6 elements which may indicate that an institution falls within the ambit of Article 12. Your corporation is held by government. Secondly, where financial assistance of the state is so much as to meet almost entire expenditure of the corporation. Thirdly, where the corporation enjoys monopoly status conferred by state or state protected. Fourthly, existence of deep and pervasive state control. Fifth, if the functions of the corporation are of public importance and are closely related to governmental functions. And lastly, if a department is transferred to a corporation. To Lordships, it is humbly submit that the internet platforms in question do not qualify any of the conditions laid down in the case of Ajay Hasia. Neither are they given any financial aid by the state, nor the state exercises wide and pervasive control of these platforms. To Lordships, as far as the condition of monopoly is concerned, as mentioned by my learned counsel, that the internet platforms in question enjoy 95 to 98% market share in their individual segments. The council humbly submits that it is pertinent to note that as laid down in the case of Ajay Hasia versus Khalid Mujib, it was laid down that the monopoly has to be state conferred or state protected. In the instant case, your lordship, the monopoly, even if exists, the monopoly of the internet platforms is not state conferred or neither is it protected by the state. For the
Council,
lordship,
you are sticking to Ajay Hasia only. No
Indeed.
doubt Ajay Hasia and Pradeep Biswas were big benches.
Indeed.
But thereafter the law of Article 12, the dimensions of Article 12 were completely changed.
Indeed,
Of
your
course,
lordship.
not, I mean, reversing the same, but at the same time, we have re-telephony, and then we have another judgment, BCCI judgment,
Indeed.
and all those judgments where the ambit of Article 12 has been expanded.
Indeed, your
So
lordship.
you can't simply stick to Ajay.
Indeed. In this regard, the Council humbly submits that as far as the test of public functions is concerned, it is submitted that in case of Ramakrishna Mission versus Kago Punia, it was established by the Honorable Court that public functions are such functions which are similar or closely related to the functions performable by state in its sovereign capacity. These are the functions that can be performed by state alone. In this regard, your lordship, in the instant case, any of the functions performed by the internet platforms in question cannot be said to be such functions that are performed by state in its sovereign capacity. They are not in relation to the governmental functions of the state. In furtherance of this, your lordship, the council submits that merely providing a medium for dissemination of information cannot be termed as a public function. Additionally, your lordship, for an activity to be classified as a public duty or public function, it is a prerequisite that a positive obligation should be cast on the institution to protect that fundamental right or to protect that duty. In the instant case, your lordship, any such positive obligation on the part of the internet platforms in question is absent in the instant case. Your lordship, it is further submitted that the relationship between the petitioner and the user provider arises out of a private contractual agreement. The services rendered by any of these internet platforms in question are in the nature of voluntary service and are in the commercial capacity. Your Lordship, it has been judicially established that voluntary functions cannot be termed as public functions or cannot be put in the category of public functions. In the instant case, Your Lordship, the functions performed by the internet platforms in question are voluntary and in commercial capacity. Therefore, Your Lordship, the element of public function is absent. Even if horizontal application of fundamental rights is considered in the instant case, the element of public functions in the instant case is mentioned. Since the internet platforms in question do not perform any of the public functions, therefore, Your Lordship, fundamental rights cannot be imposed against any of the platforms in question. Your Lordship, it is worth noting that as per para 13 of the fact sheet, the accounts of the petitioner were not completely suspended, but the access was limited, keeping up with the terms and conditions of the internet platforms in question, which the user himself agreed to. Your Lordship, the Council now seeks permission to address the issue of whether the terms and conditions as agreed by the petitioners are binding on him. Much obliged. In this regard, Your Lordship, the Council humbly submits that the terms and conditions as agreed by the petitioner in question are binding on the petitioner in a two-pronged argument. Firstly, it constitutes a valid contract, and secondly, click-wrap agreements are held equally enforceable. Your Lordship, the Council humbly submits that the contract that arises between a user and the service provider or the internet platforms in question can be put in the category of click-wrap agreements. Click-wrap agreements are the agreements where the user manifests his consent by pressing the icon of I agree under beneath the terms and conditions of the platform if they are made by free consent of parties competent to contract. For the lawsuits, in the case of standard or click-wrap agreements, a party consents to such a form of contract by manifesting assent. The lawsuits, in the instant case, the assent of the petitioner was manifested when he clicked the icon I agree, and in the instant case, the lawsuit, the consent of the petitioner in question was free and voluntary. The petitioner himself agreed to the terms and conditions as laid down by the internet platforms in question. Therefore, your lordship, it cannot be said that the terms and conditions or the contract that arise out of the terms and conditions was invalid because the consent that was given by the petitioner in the instant case was free and voluntary, which fulfills the essentials of Section 10 of the Indian Contract Act, and henceforth a valid contract has been established, and now the petitioner cannot back out of the contract of the terms and services that he himself consented to.
So
Further, Your Lordship,
you did not give the petitioner any choice or any option to bargain with the terms and conditions of laid down in the contract. He had no choice but to agree to all the conditions, whether they were arbitrary or they were acceptable to him. So in the end, if he finds any of the conditions being arbitrary or being violative of his fundamental rights, he has an option to challenge it. And he has an option to give a say that such condition is not acceptable to me.
indeed, Your Lordship, the Council humbly submits that even if there existed a lack of negotiating power, the petitioner still voluntarily consented to the terms and conditions which were clearly laid down before the petitioner. The petitioner voluntarily consented to those terms and conditions. Additionally, Your Lordship, the internet platforms in question are some of the many platforms that already exist in the society, exist in the market. Your Lordship, in the instant case, the petitioner voluntarily chose to avail.
Organization versus a small individual. There is no comparison.
Indeed,
The negotiation can happen between two equivalents.
indeed.
Here it is one business magnate, another a simple individual.
Indeed, Your Lordship, the Council in this regard humbly submits that it is the era of technology and most of the contracts in the present age are contracted through electronic medium. Further, Section 10A of the Information Technology Act upholds the validity of contracts made through electronic medium. Your Lordship, if the contract that has been established between a user and a service provider by the medium of electronic medium, if all such contracts, if all such click-wrap agreements are invalidated merely because the petitioner or the user was not vigilant enough to go through the terms and conditions, or merely because the petitioner had a lack of negotiating power, all such click-wrap agreements would lack enforceability and lack invalidity, which would not be very feasible considering that it is the era of technology and the service providers, which have a very wide base, which have a global base, they cannot be expected to consider or to negotiate with individuals, with each and every individual, considering the wide and pervasive base. What they can do is lay the terms and conditions, and if the petitioner or the user finds the conditions suitable to him, the user can agree to those conditions. Therefore, you also given the wide and pervasive control and the global base, the service providers cannot be accepted to particularly and individually negotiate with each and every user. Lordship, such a measure to invalidate all the click-wrap agreements would not be feasible, considering that it is the era of technology and technological advancement.
There is a question, Madam Counsel, question posed by both my lords was not that click-wrap agreements are not applicable or they are not enforceable. The question was that if fundamental rights are infringed in the garb of such an agreement, can it be sustained? That is the question.
Your Lordship, the
Particularly
council.
when the state, the company is a mighty an organization and the small user.
Indeed. Your Lordship, in this regard, the Council humbly submits that firstly, fundamental rights are not enforceable against the internet platforms in question as proved by the Council beforehand. And secondly, the contention is that the fundamental rights are infringed because there exists a lack of negotiating power between the two parties. The one of the parties is just an individual, and the second of the party is a global market in itself. Lordship, this is what the council contended that even if there exists a lack of negotiating power, the contract that existed between the petitioner and the service provider cannot be struck down merely on the condition that there existed a lack of negotiating power and the petitioner petitioner did not go through the terms and conditions, and the petitioner was not well vigilant of what he is consenting to. Losses when a petitioner, when a user is consenting to the terms and services of any of the service providers of the services that he is availing, he is meant to go through the terms and conditions vigilantly enough. For the losses, the internet platforms in question specifically provide at the bottom of the agreement that by agreeing to the terms and services, by clicking the icon of I agree, you are consenting to all the terms and conditions as laid down by the platforms in question. As such, losses, there exists a proper valid agreement and the petitioner is bound by the same considering the same. Your Lordships, if there are no further queries, the Council seeks permission to address the next issue. Your Lordship, the fourth issue primarily pertains to whether, in absence of any statutory provision enshrining presumption of innocence, can the petitioner claim any relief, and further, whether honorable technical acquittal, being a long established aspect embedded in service jurisprudence, whether it will be prudent to disturb the same at this stage. Your Lordship, the Council shall first address the issue of whether, in absence of any statutory provision regarding presumption of innocence, can the petitioner claim any relief. In this regard, Your Lordship, the Council humbly submits that in absence of any such provisions, the petitioners cannot claim any relief in a two-pronged argument. Firstly, degree of proof required to establish the guilt in criminal trial and disciplinary proceedings vary. And secondly, rules of evidence and criminal trial procedures do not apply in the case of disciplinary proceedings. The Lordship, it is humbly submitted that in disciplinary proceedings, charges are established using the doctrine of preponderance of probabilities, whereas in the case of criminal trials or criminal procedures, the doctrine of proving the guilt of the accused beyond reasonable doubt is followed. The Lordship, furthermore, it has been judicially established that the employer always retains the right to conduct an independent disciplinary proceedings regardless of the outcome of a criminal case. The outcome of a criminal case becomes irrelevant when it comes to disciplinary proceedings. Further, Your Lordship, the judgments of the criminal court or criminal trial cannot be considered for the purpose of absolving an employee in disciplinary departmental proceedings. In the instant case, Your Lordship, as per para 16 of the fact sheet, although the petitioner in the instant case was acquitted by the honorable court, it was merely because the prime witness turned hostile and the prosecution failed to establish the guilt of the accused, the guilt of the petitioner beyond reasonable doubt. Your Lordship, this is not enough of proof to prove that petitioner was innocent. In the instant case, the acquittal was technical and not honorable. The accused was acquitted because the prime witness turned hostile, and as a consequence, the prosecution failed to establish the guilt of the accused beyond reasonable doubt. Your Lordship, it is further submitted that rules of evidence and criminal trial procedures do not apply in case of departmental proceedings. Your Lordship, if you may please refer to para 46 of the arguments advanced. In the case of Karnataka Power Transmission Corporation versus C. Nagaraju, it was observed by the Honorable Court that in departmental proceedings, the question is whether the respondent is guilty of such a conduct as would merit his removal from the service. In the instant case, Your Lordship, the petitioner was accused of misconduct and subordination. Therefore, Your Lordship, the department holds the right to conduct independent departmental proceedings where the decision in the criminal proceedings or in the criminal court become immaterial. Further, Your Lordship, as far as the issue of whether honorable technical acquittal, distinction between technical and honorable acquittal, would it be prudent to disturb the same at this stage? Your Lordship, the Council submits that this particular disturbance would violate the doctrine of stare decisis. The aspect of technical and honorable acquittal is well established in service jurisprudence and accepted by the courts over decades. For this particular statement, the Council would refer to the case of Management of Reserve Bank of India, New Delhi versus Gopal Singh Panchal, wherein it was held by the Honorable Court that the Council seeks permission to sum up the arguments.
Why you took 8 years to do that?
Your Lordship, the Council humbly submits that this is a matter which can be dealt through a different petition. In the instant case, the issue which is concerned is whether the distinction between technical and honorable acquittal is a well-established principle and would it be prudent to disturb the same at this stage. In this regard, Your Lordship, the Council submits that as per the case mentioned by the Council, it has been held by the Honorable Court that mere acquittal does not entitle an employee to reinstatement in service. The acquittal has to be honorable. Therefore, Your Lordship, as recognized by the Honorable Court over years and years, the distinction between honorable and technical is well established in service jurisprudence. Therefore, it would not be prudent to disturb the same at this stage.
Under
As you have pointed out, the only evidence in the criminal case was of the witness of that fellow, the person. And in the disciplinary inquiry also, the same evidence is required to be led, who has been examined before the criminal court, and he has not supported the prosecution case. Then how will you have any other decision in the disciplinary inquiry? Because it is based on the same facts.
Indeed, Your Lordship. Your Lordship, the council firstly mentions that the charges that are leveled up against the petitioner in the instant case by the department are of misconduct and insubordination, whereas the charges in the criminal court are that of defamation and extortion.
Correct. But for sustaining those charges, you are required to lead evidence. And the evidence which has been, the only evidence which has been led before the criminal court is of that CEO. And he has not supported. So is there any different evidence material which is before the disciplinary inquiry to come to a different conclusion?
Your Lordship, it is humbly submitted that the disciplinary proceedings in the instant case are still in continuance and the same shall be established if any evidence, if exists, the same shall be established through the departmental proceedings. Your Lordship, the
and
council.
under you had placed him under suspension for good 9 years, under which provision of law you withheld his subsistence allowance.
Your Lordship, the council humbly submits that the aspect, as even mentioned by my learned counsel, that he was denied of any subsistence allowance, the facts in the instant case are silent upon the same, and it is a mere assumption of my learned counsel in the instant case. Your Lordship, if there are no further queries, the council seeks permission to address the prayer. Wherefore, in light of the facts stated, issues raised, authorities cited, and arguments advanced, it is most humbly submitted before the Honorable Court that it may be pleased to declare, firstly, there are well-established mechanisms under existing regulatory regime to deal with the grievances sought by the petitioner, therefore, instant petition should not be maintainable. Secondly, denial of access to the named internet platforms in question cannot be said to be a violation of any human or fundamental right, and and the terms and conditions as agreed by the petitioner are binding upon the petitioner. Thirdly, categorization of an acquittal as honorable and technical is legal and in consonance of the constitutional mandate. And lastly, in absence of any statutory provision enshrining presumption of innocence, petitioner cannot claim any relief, and the distinction between honorable and technical being a long established aspect in service jurisprudence, it would not be prudent to disturb the same at this stage and or pass any order that this honorable court may deem fit in the furtherance of justice, equity, and good conscience. For this act of kindness, the council on behalf of the respondent shall duty bound forever pay. The Lordship, it was indeed an honor to argue before the honorable bench.
For what? Rebuttal. Rebuttal? Yes, time for rebuttal. How much time for rebuttal?
My lord, that is a saying in the legal fraternity. When you have facts, you state the facts. When you have law, you state the law. And when you have none, you just beat around the bush and leave ends unknown. That's what my learned friend has been trying to do for the last. My lord, firstly, it must be noted that since heavy reliance has been placed upon the Digital Data Protection Bill 2023, the Intermediary Guidelines 2020-21, it is a question whether such statutes have a retrospective application. Because when the violation occurred, the year was 2015. These laws were not even in place at that time. So are these statutes supposed to apply retrospectively? Further, my lord, even if I consider that 2020-21 rules exist, it must be noted that even 2020 rules, the last decisions by the ministry itself, which is a part of the government itself. It is not by an independent body which the petitioners have been claiming. Further, my lord, it must be noted that since they have been stating that we have accepted the terms and conditions, my lord, the terms and conditions of the platform have been produced before my lord for reference, which particular term and condition states the same that a fundamental that such a right could be taken away in a case I post such and such content. Further, my lord, it must be noted that they are question the public function of the platform. Lord, this is a very contradictory statement because firstly, it must be noted that what is Akshar doing? Akshar is regulating the fundamental rights. Further, my lord, they say they defend the actions that the reasonable restrictions can be imposed upon fundamental rights. My lord, who can impose reasonable restrictions? Who can impose reasonable restrictions? That a body which performs functions for the government. Further, my lord, it must be noted that since a reference has been made to moral turpitude, my lord, moral turpitude is a ground for consideration where there is a denial, where there are grounds for denial of claims for gratuity. My lord, has the management made up its mind that the employee will be dismissed now, that they are bringing about the concept of moral turpitude also all of a sudden? Further, my lords, my learned friend have relied upon the trend of deviating from the written submissions. My lords may refer to page 4 of the written submissions filed by the respondent. My lords, but the heavy reliance has been placed into the concept of mergers and amalgamations. My lords, how is mergers amalgamations even relevant to the instant case? Lastly, my lords, I would like to state that since they have been referring upon the doctrine of preponderance of probability, my lords, want to ask, specify the standing orders clause. Which probability are you basing the charges on? Specify the clause itself. And my lord, lastly, when you say that that a government order, the government upon a order of the High Court, yeah, we could take away your rights. My lord, so are you acknowledging your fault? Because in the instant case, there was no High Court order to take away our rights. You did it at your own discretion. That's all, my lord. The rest. It was indeed honor period.
You'll also still humbly submitted that as pointed by my learned counsel, that whether the DPDP Act has retrospective effect, the council is misleading from the issues. The issue is whether there exists any regulatory regime in the present. There do exist the regulatory regimes in present, DPDP Act, IT Act, and the petitioner still has the right to approach under those acts. So, the council feels that my learned counsel has deviated from the fact. Further, as pointed out by my learned counsel, that the respondents are applying reasonable restrictions under Article 19, Clause 2, which only state is allowed to impose. It is humbly stated that that the respondents in question did not argue upon the reasonable restrictions under Article 19, Clause 2, but merely stated that the petitioner is bound by the terms and conditions that the petitioner himself agreed to. Further, Your Lordship, as far as the question of mergers and acquisitions is concerned, in the written submission, the respondents mention those facts to merely state that CCI in this instant case has jurisdiction over the matter. Your Lordship, it was indeed an honor to us.